So the first thing I would say is that there are a large number of cases that need to be dealt with. And as we've said, that this is not a process that can be done quickly. It takes time, and it shouldn't be rushed. In terms of the composition of the tribunal as to whether we need a second tribunal or a second trial chamber, I think that is very likely. One of the matters that I've raised with the Chief Prosecutor, I've also raised with the law advisor, is in my view, the requirement to structure the tribunal in a way that it can, first of all, meet public demands, that it can operate in accordance with the rule of law, and that it can deal with matters fairly and expeditiously. When we say expeditiously, it means that people are not held in custody for unreasonable lengths of time, and the trial process can go forward. In that way, I think that it's required to look at how it is set up, to identify whether structural changes should be made by way of creating a second tribunal, by way of creating different trial panels. One of the arguments that I've made is that, and I appreciate that this may go contrary to traditional practice in Bangladesh, is that ordinarily when you have a tribunal such as this to deal with what are international crimes, war crimes, crimes against humanity and genocide, you will have a single judge who would sit on all procedural matters, and then you'll have a trial panel of 3 judges that deal with the trial, and then you will have an appeal panel. And I think that's one of the things that we need to think about as to whether in the future, for the longer term, to ensure that justice is done and justice is seen to be done, that the process is structured in a way that meets all of those demands. So when we say tribunals, we mean a panel of 3 judges. So my view on what needs to be structured is having a single tribunal that is composed of different trial panels. Maybe you have 2, maybe you have 3. But in many of these things, a lot of this is dictated by the funding. How much funding do you have available? Because, of course, when you have a panel of 3 judges or a separate tribunal, they need to have support. They need to have logistical, technical, and human support in order to do these trials. It's not just a matter of having 3 judges that can sit on a trial. There's a lot of support that needs to go with that. And so I think one of the things that we need to think about is how do we strengthen the registry at the tribunal, because the registry plays a very important role. How is the prosecution structured? Are there enough prosecutors? Are there enough investigators? Are there enough support staff? And so there are a number of questions that you have to be able to answer before you can even make a determination as to how many tribunals or how many panels of judges you're going to require. The other thing that you have to factor into the discussion also is what is the intention? Is the intention to prosecute every case, to bring every perpetrator to justice? Because that's a very unrealistic expectation. And you have to understand that in a process such as this, what you need to have is, first of all, you focus on those most responsible, those in positions of senior leadership, to ensure that they are brought to justice through a fair judicial process. But what you might also need to consider, because we're not just talking about July, August, we're talking about a period of 16 years, we're talking about large-scale disappearances, enforced disappearances, extrajudicial killings, arbitrary detention, torture in custody. There are a huge number of cases to look at. And you have to recognize that the state is not going to be able to address all of those cases through a criminal justice process. And you have to then start to look at other alternative mechanisms, other routes of transitional justice that bring about reconciliation, that bring about truth-telling exercises. And so those are things that falls outside of my mandate, because my mandate is to advise the prosecution, but these are things that the government is going to have to consider for the long term. So, I mean, first of all, it's a question of whether the public are satisfied with how the process is operating. It's a question of whether there is public confidence in the process. Of course, no institution is perfect. I mean, I can tell you I've worked at institutions in Bosnia, on Kosovo, and a range of different situations, and no system is perfect. You need to get it to a stage where it meets the standards required for domestic law and international fair trials. Now, of course, we have made recommendations previously for amendments to the legal framework that were necessary. I've made additional recommendations for additional changes to make sure that the trial process is fair. I've made recommendations as far as how I think that the staffing levels in the prosecution needs to be increased. But the one thing that I can say is that when I first came here and I first started to have discussions with the various different actors, including the Chief Prosecutor, the Law Advisor, the Attorney General, and even the Chief Advisor, is that I was more than happy to assist in this process as long as I could see that there was a real commitment to justice, that there was a real commitment to uphold the highest standards of fair trial, and no matter what the public demands are, and no matter what people consider, whether this is a process aimed at vengeance, my comments were always that I will not participate and I will not facilitate a process unless I'm satisfied that there is a real commitment to that. And that was made very clear to me at the very beginning, is that this is a break from the past. No matter what was done under the previous administration, the previous regime, will not be repeated now. Anyone who is brought before the tribunal must be afforded the highest standards of due process. Fundamental rights must be respected. They must be able to be properly represented by counsel, to be able to properly participate in that process, and to properly represent the interests of those accused. Because if you set up a process like with the previous regime that was aimed at manipulating and politically interfering with the process, then that serves no purpose as far as re-establishing the state as a democracy. And justice and the rule of law is at the heart of a democracy. And so if we want to see Bangladesh as a democracy with full respect for the rule of law, then this is where it starts. This is where it has to start, and we have to demonstrate to the public that there is that commitment, a real commitment, to see that justice is done and that is seen to be done.